Well, a very good morning to everyone and welcome to the latest instalment in our series of 5 webinars on cargo claims. I'm Tom Hodges, a partner in the Birketts Shipping and International Trade team, and I'll be presenting today with Alex Smith, who is a senior associate in the team. Today's webinar is the fourth of 5 cargo claims talks, and there's admittedly been a bit of a gap since the previous webinar due to various commitments in the team, but it's great to get things back on track today. And you can find the earlier 3 webinars on the Birketts YouTube channel, and links to those have also been included with your invite to today's webinar in case you want to catch up or refresh. And so today's webinar is on evidential issues in cargo claims, and this is what the talk will broadly look like. First, I'll give a brief introduction, and seeing as it's been a while since the last talk, I'll just give a quick overview of Birketts as a firm, and also update you on the Shipping and International Trade team, which has grown considerably since the last webinar. I will then hand over to Alex, who's going to run through the main substance of today's talk on evidential issues concerning bills of lading and the receipt function. And we'll then move on from bills of lading to consider some other issues, including issues concerning burdens of proof in cargo claims, and also the implications in relation to other evidential issues concerning the carriage of cargo at sea. And finally, we'll also touch briefly on the issue of mitigation. Okay, so just to briefly introduce Birketts as a firm, well, the firm first came into existence over 160 years ago when Benjamin Birketts set up shop in Ipswich. And since then, the firm has grown beyond recognition into the UK top 50 practice that Alex and I are part of today, with 1,200 people based across 7 offices. And we cover a full range of services, including corporate and real estate and those kind of core practice areas, along with a number of weird and wonderful niches. And forming a small but very important part of those 1,200 people are the 23 or so good folk in the Birketts Shipping and International Trade team. We have a long-established shipping team, which has offered an outside London option for those requiring maritime legal services for a number of generations now. And most of our team continue to be based outside London in either the Ipswich or Bristol offices, which means that we remain as well placed as ever to offer competitive rates for our work. But we also make regular use of the London office to see clients and keep in close touch with the UK market as well. So we benefit from the best of both worlds. And in terms of the team's core practice areas, well, we're a full service marine trade and marine insurance team, and we cover all of the work types that you would expect to fall under that umbrella. And we regularly handle cargo claims with certain lawyers in the team acting as both claimant or defendant. And just to be clear, the purpose of this talk, or the aim of this talk, is to remain as neutral as possible in relation to either side of the cargo interest and carrier divide. We also have extensive expertise in giving charter party advice, for example, FD&D advice and charterers liability advice as well as advising on insurance issues such as policy coverage points and also advisory work in relation to insurance policies as well. And finally, we also cover the other topics that are set out on this slide. And as you can see, there's a good breadth of expertise to our practice area. And this has been enhanced in particular by the addition of our Bristol office when our colleagues in Bristol joined us last September, specialising in particular in work types such as yacht work, ports and terminals, maritime injury investigations, as well as the insurance policy work that the Ipswich and London teams do as well. And finally, at the bottom of this slide, you'll see a couple of nice things that clients have said about us over the last year or so, and so hopefully we're doing something right. Okay, so moving on to the substance of today's talk, and just first of all, to put things in context, you'll be aware by now that the bill of lading has 3 functions. And if you need to catch up on this, then the first 2 functions on this slide here have been dealt with in earlier webinars, so you can look back and refresh. But what we're mainly concerned with today is the third function on this slide, which is the function of the receipt, the function of a bill of lading as a receipt for the goods carried. And so what do we mean by that? Well, let's first remind ourselves of where bills of lading sit in the bigger picture regarding the sale and shipment of the cargo. Okay, so the next few slides should be familiar to those of you who've seen some of our earlier talks, and what they provide is a helpful kind of way of setting the context as to where bills of lading sit in the overall picture concerning the sale and shipment of goods. And what we have here is the starting point, so the catalyst, if you like, for the more complex web of shipping contracts that comes afterwards. And what we have here is a sale contract, or in fact a sale contract chain here, where a particular cargo is sold by the first seller to an intermediate buyer and then on to a subsequent buyer of the goods. Okay, so all fairly straightforward so far. Okay. And one of the terms of these sale contracts will relate to the shipment of the goods. For example, in an FOB, free on board contract, which is the first sale contract example that we have on the slide there, all the seller has to do is to deliver the goods, and it's then for the buyer to arrange the transportation from the point of delivery. And with the second sale contract there on CIF, carriage insurance freight terms, the seller will usually arrange carriage and deliver the goods by placing them on board the carrying vessel for subsequent sea carriage to the final receiver. But either way, in order for the terms of the sale to be fulfilled, both from a legal and commercial perspective, there will need to be a ship to move the goods to where they need to be. And so one of the parties in the sale contract, i.e. the party with responsibility for arranging carriage, will go into the market to fix a ship. And as we can see here, it's the intermediate buyer, so the FOB buyer under the first sale contract and the CIF seller under the second contract. That buyer will go into the market, fix a ship, as it has done here, in the form of a voyage charter party with the sub-charterer, and above that voyage charter will then sit a number of further other charter parties up to the head charter party at the top, which in this instance is a time charter between the head owner and the head time charterer. Okay, and then once the charter party has been agreed, eventually the vessel will proceed to the load port in accordance with the terms of the charter party, hopefully arrive within the contractual laycan, which is the period during which the vessel must arrive in order to begin her employment with the charterer, i.e. the intermediate buyer here in this sale contract chain. And then once the vessel is berthed, loading can proceed. Loading will take place, hopefully without hitch. And then once the loading is complete, the shipper of the cargo will want something to show that custody of the cargo has transferred to the carrier. And so once the cargo is safely on board, the carrier will then issue and sign a bill of lading. And as we know, that bill of lading will have several functions. But one of those functions is that it will act as a receipt for the goods. And the bill of lading might be signed for and on behalf of the master, in which case it would be what we call an owner's bill. Or it might be signed on behalf of one of the charterers further down the charter party chain, in which case it would be a charterer's bill. But in terms of the receipt function, the effect is the same. The bill of lading, once signed by the master and given to the shipper, will act as a receipt for the goods. And we'll look in a bit more detail as to the meaning of the receipt and the effect of the receipt function in the coming slides. And now the references at the bottom of this slide refer to the function of a bill of lading as a document of title, which is capable of passing rights from the shipper to a subsequent transferee or endorsee and on to a further transferee until eventually it gets to the final receiver of the goods at discharge port, who can exchange the bill of lading for the delivery of the goods. And the detail of the terms on which rights are transferred under a bill forms the subject matter of earlier webinars. So you can go back and have a look at those. But just to set the context for this particular talk, Alex will be referring to transferees and endorsees later on during his part of the talk. And when you hear that, this is what he's referring to: the passing of rights from one party in the sale contract chain to the next by means of endorsements on the reverse side of the bill of lading, along with the passing of physical possession of the bill from one party to the other. Okay, and then just one final kind of recap or piece of context setting. You'll remember from earlier talks that English law cargo claims are almost always subject to either the Hague or the Hague-Visby rules. And this can either be because the Hague-Visby rules apply on a compulsory basis, usually because the cargo is loaded in a Hague-Visby contracting state, or it might be because the Hague or Hague-Visby rules are incorporated by contract. And where the Hague or Hague-Visby rules are incorporated by contract, this will usually be by means of a clause paramount. And on this slide, we have an example of a clause paramount, which is actually taken from the reverse side of the Comgen 1994 bill. And as you can see there, the effect, I won't read it out, but the effect there is to incorporate the Hague rules under the terms of the Bill of Lading, and that will apply in circumstances where the Hague-Visby rules do not apply on a compulsory basis. And again, the detail of that formed the subject of the previous webinar, webinar number 3. So go back and look at that if you feel so inclined. But you'll hear reference to the Hague and Hague-Visby rules during this talk. So it's just important to have in mind the basis on which those will apply. Okay, and now that the scene is hopefully set, I'm going to hand over to Alex, who is going to look in more detail at the receipt function of the Bill of Lading.
Thank you, Tom. So where the Hague or Hague-Visby rules apply, Article 3, Rule 3 provides, after receiving the goods into his charge, the carrier or the master or agent of the carrier shall, on demand of the shipper, issue to the shipper a bill of lading showing, among other things, A, the leading marks necessary for the identification of the goods, as the same are furnished by in writing by the shipper, B, either the number of packages or pieces, or the quantity or weight, as the case may be, as furnished in writing by the shipper, and C, the apparent order and condition of the goods. And this is qualified by the following words: provided that no carrier, master, or agent of the carrier shall be bound to state or show in the bill of lading any marks, number, quantity, or weight which he has reasonable grounds for suspecting not accurately to represent the goods actually received, or which he has no reasonable means of checking. So just to break that down, leading marks, well, a cargo won't always have leading marks, and they won't always appear on the bill of lading, but an example of a leading mark which would be necessary to identify the cargo would be a container number, and that would, with a containerized cargo, that would always pretty much be on the bill of lading. Another example would be if you have a bagged cargo of rice or sugar or something like that, you might have brand names that are printed on the bags, and the shipper might put those on the draft bill. But as I said, not all cargoes will have them. Generic cargoes almost certainly not. And then the carrier is obliged to say either the number of packages or pieces or the weight of the goods shipped. So again, that just depends on the cargo as to which of those are stated, and then the apparent order and condition of the goods, to which I will return. So once it's been issued, a bill of lading will be prima facie evidence of receipt of the goods and of the facts stated on it. So an example of the facts stated on the bill would be the fact that the goods have been shipped and the date of shipment, the weight or quantity of goods shipped, a description of the goods, and the apparent order and condition. And these are all factual representations. They're not contractual promises or guarantees. And as I said, as between the shipper and the carrier, they're prima facie evidence of the condition of the goods. However, although statements on the bill of lading are only prima facie evidence as between the carrier and the shipper, they can give rise to an estoppel in favour of an endorsee, provided that the endorsee did not know that a particular statement was false before the bill was endorsed to them. And I'm going to talk about estoppel later in this talk. But because of the evidential value of statements made on the face of the bill of lading, it is in the shipper's interest to obtain a bill of lading saying everything is fine and satisfactory. That is, for a clean bill of lading to be issued without any reservations at all about the goods. Conversely, it's in the carrier's interest for any statements made by the master on the bill to minimise liability. And we're going to talk about clausing and qualifying statements later in this talk. So I've actually got an example of a bill of lading, which I think Olivia can make appear larger on your screen. And this again is the Congen Bill 1994 at the front of it, which is probably the most common bill of lading you see for bulk cargoes. And this particular cargo was Ukrainian corn, so it's a generic cargo. The description says 2016 crop in bulk. So there's no leading marks because it's a generic cargo, but it does state the weight there, the gross weight in metric tons. And then if we go down to the small writing at the bottom of the bill, it says shipped on board the port of loading in apparent good order and condition. So those words are actually printed on the Congen bill. And then there's an unknown clause further down, which I should go on to discuss shortly. So in terms of the apparent order and condition of the goods, well, the carrier is obliged to record that on the bill of lading. Unlike other requirements of Article 3, Rule 3 of the Hague Rules, this information is not supplied by the shipper in the form of a draft bill. It's a statement based on the master's assessment of the goods. And the apparent order and condition generally relates to the external condition of goods, ascertainable on reasonable examination by the person issuing the bill, so probably the master. And in terms of the standard required, the standard of care required, the master or the carrier is expected to record the condition of the cargo honestly and reasonably. So, as I mentioned, we're talking about the external appearance of the cargo. So if, say, you had a project cargo and the cover missing, or it's obviously scratched, or you've got a bagged cargo and there's mold, visible on the outside of the bags, these are all things that the master would sort of be expected to record, but he's not expected to go opening containers or unpacking cargo. So, as I said, we're talking about the external condition. Now, if the master does have a reservation about the order and condition of the cargo, he should consider clausing the bill. And so, as I've said, traditionally a shipper would draft the bill of lading and provide it to the master for signature. And as we've seen with the Congen Bill 1994, it will probably already have the words shipped in good order and condition printed on it. So what does the master do if he disagrees with those words? Well, he can clause the bill, and that is often in practice just a handwritten note on the front of the bill that might say something along the lines of, depending on what the cargo was, cargo is scratched, cargo is rusty, bags are mouldy, something like that. But technically, the master must use words that reflect reasonably closely the actual apparent order and condition of the goods of the cargo and the extent of any defective condition which he, as a reasonably observant master, considers it to have. Now, where the master fails to clause a bill of lading, when the goods are not in apparent good order and condition, owners will be stopped from arguing that the damage observed at discharge occurred pre-shipment. And a estoppel is an English law doctrine where one party, which comes into force, where one party makes a unilateral, unequivocal representation, which the other party relies on to its detriment, for instance, by entering into a contract. And then it's said that the party which made the representation may be stopped or precluded from going back on that representation. So Tom's now going to talk us through a practical example of a case where the master did fail to clause the bill of lading and the consequences of that.
Yeah, thanks, Alex. So this was a case that we were involved in several years ago now. It was resolved in arbitration, I think back in 2021. And what happened in this particular case was that a cargo of sugar worth around $2.1 million was involved, first of all, in a warehouse fire in Santos in Brazil prior to loading. And you can see in the photo on the right-hand side there the condition of the warehouse towards the point where the fire had been extinguished. And you can see that the roof was almost completely destroyed there. In fact, you can see the smoke still coming up the top of the building, top of the warehouse in that photograph. And some fire vehicles there, fairly indiscriminately spraying water on the warehouse to put the fire out, very much as you would expect. And of course, one would expect anything in that warehouse to have been, exposed to the effects of the fire, the smoke and the heat damage, along with the water and other materials that we used to try to put the fire out. And so the fire was eventually resolved. Cargo from within the warehouse was then loaded on board the carrying vessel. And perhaps unsurprisingly, during the loading process, which was attended by surveyors, including a P&I surveyor on behalf of the ship owners, some damage to the cargo was noted. Although at the same time, there was no record of any of that damaged cargo being segregated or treated in a way that was different to the sound cargo that was loaded at the same time. And so a clean bill of lading was then issued by the master. There was no clausing on the bill to indicate damage present on loading. And the vessel underwent its laden ocean voyage. And then when she arrived at the discharge port and discharge began, the surveyors who attended on behalf of the various interests noted quite extensive damage within the cargo hold. And on this next slide, you can see on the left-hand side there. So this is after the cargo had been discharged from the vessel into a warehouse near the discharge port. And you can see on the left-hand side there is an example of the sound bags that were taken off the ship. And on the right-hand side are some of the fire and smoke damage bags that were also removed from the hold. And you can see that they're in a pretty sorry state, quite extensive damage present. Again, cargo interests advanced the claim in respect of the loss they had suffered. And as a kind of starting point, it was broadly common ground between the two parties, the cargo interests and the carrier, that the damage that was complained of mostly arose pre-shipment. And there was no sensible premise on which it could really be argued that any of the damage arose during the ocean voyage, given the nature of the damage, and also the fact that the parties were aware that this substantial fire had occurred. So taking that as an assumption of fact, and it's important that it's an assumption of fact and not a legal assumption, the primary basis for the cargo interest to advance their claim, despite the fact that it was common ground that the damage arose pre-shipment, was that the owners had nevertheless failed to deliver the cargo in the same good order and condition as it had been in when it was presented for loading. And this amounted both to a breach, so cargo interest would say amounted to a breach of Article 3, Rule 2 of the Hague Rules, and also a breach of owners' duty of bailment. And so the cargo interest argued the owners were stopped from arguing pre-shipment damage because the damage would or should have been apparent to a reasonably observant master during loading, either because the master or the vessel interests would have seen the relevant damage during loading, or ought to have seen it had they exercised reasonable care and skill in carrying out a reasonable inspection and investigation of the condition of the cargo during loading. And of course, the master had not claused the bills. Owner's defence, on the other hand, again premised on the fact that the damage in fact arose pre-shipment, was that this was not apparent to the master or crew and would not have been apparent on a reasonably careful inspection of the cargo. Okay, and so it was held by the tribunal that neither the ship staff nor the surveyors appointed on behalf of the ship owners exercised the appropriate standard of care and skill to properly determine the condition of the cargo at loading. Okay, so regardless of whether or not the master actually observed damage in the cargo, it was held that a proper investigation had not been carried out. Nevertheless, it was held that the master was clearly aware that there were damaged bags that were loaded into the cargo holds, not removed or segregated, and therefore that the cargo was clearly not loaded in an apparent good order or condition. And despite this, the master failed to clause the bills of lading. There were no marks on the face of the bill to indicate the compromised condition of the cargo. The master signed the bills, gave a clean bill back to the shipper, and the tribunal held that the owners were therefore stopped from relying on the fact of the pre-shipment damage in defence of their claim, and the claim succeeded. So just to go over that again, you'll recall from Alex's last slide of his section of the talk that the position is that the shipper will present the draft, would have presented the draft bill to the carrier, and the carrier would have then had the opportunity to clause the bill with its observations of the condition of the cargo, but failed or elected not to do so, signed a clean bill, handed the bill back to the shipper. The rights under the bill would have then passed to the receiver at the discharge port by means of endorsement, along with transfer of physical possession of the bill. So the receiver at this point then has the bill as the transferee, and at that point, the receiver will then take the bill, take delivery of the goods in reliance of the fact that it has a clean bill of lading, and that detrimental reliance will then create an estoppel against on the part of the owners, with the effect that the owners are no longer able to rely on the pre-shipment damage in defence of the claim, and that's exactly what happened in this particular case. And damages were awarded, substantial damages were awarded in favour of cargo interests. So what that claim, which we handled within our team, provides is obviously a salient lesson to a carrier that where damage is observed during loading, despite the fact that there may be some commercial pressures on the carrier to issue a clean bill of lading, there can be really quite serious repercussions for failing to clause the bill appropriately when you have the opportunity to do so. And indeed, it can also have repercussions for the P&I cover that the carriers might otherwise benefit from, in that P&I insurers, as some of those listening to this talk will know better than me, will no doubt be asking some fairly serious questions as to why a ship owner has failed to observe problems with the cargo when it had the opportunity to do so at loading. Thanks, and I'll now hand back to Alex to talk about letters of indemnity.
Thank you, Tom. The shipper may require a clean bill of lading, for instance, to get paid by the buyer for the goods he has sold and shipped. So if the master has reservations about the order and condition of the cargo, the shipper may nevertheless try to persuade him to issue a clean bill of lading in return for the shipper issuing a letter of indemnity, or LOI, to the carrier. Now, the LOI would state that the shipper will indemnify the carrier against the consequences of issuing a clean bill of lading, such as being sued by the consignee. But there's a number of points to note. Firstly, an LOI would not relieve the master of his duty to act reasonably in assessing the condition of the cargo. And secondly, under English law at least, an LOI will not be enforceable if the master knew that the cargo was not in apparent good order and condition at the time when he issued the clean bill. So, and moreover, the carrier may even commit misrepresentation or fraud if it issues a clean bill of lading in the knowledge that the goods were in fact damaged, and that may prejudice the carrier's club cover. So I referred to unknown clauses earlier in this talk, and on the slide we've got the unknown clause from the Congen Bill 1994 that we saw earlier. So the evidentiary effect of statements about the goods on the bill of lading may be negatived or qualified by further provisions on the bill, and these are typically inserted to protect the carrier, particularly when the master's got no means of checking the accuracy of statements made by the shipper. And where there is conflict between the description of the goods and the unknown clause, is a question of construction of the bill of lading as a whole, as to whether the bill of lading still constitutes prima facie evidence in relation to that matter. So a bill of lading will retain its evidentiary function in relation to matters not covered by the unknown clause, but the unknown clause will be construed restrictively. So, for instance, weight unknown will not the words weight unknown will not negative a statement as to the number of packages loaded, because that's a different issue. Now, the unknown clause on the slide is quite comprehensive. It provides weight, measure, quality, quantity, condition, contents, and value unknown. So there's a lot of unknowns there, but that won't always be the case. You could have an unknown clause that for instance, just provides the weight and quantity is unknown. But be aware there is a case called the Hero and the Asco from 1986, and in that case the master had signed and placed a stamp next to the quantity stated on the bill of lading, and this was held to displace the quantity unknown clause printed on the bill, because the master's bespoke words took precedence over the printed clause. And the word said to contain instead of unknown can have sometimes been held to have the same effect as an unknown clause. But the editors of Carver on bills of lading suggest that this is not always the case. So one has to be careful with that. I'm now going to hand back over to Tom, who's going to talk about burdens of proof in cargo claims more generally.
Great. So as Alex says, moving away from bills of lading at this stage and just taking a step back to consider a broader issue affecting the pursuit and defence of cargo claims, namely which party out of the claimant cargo interest and respondent ship owner or carrier will have the burden of proof in claims of this nature. When we talk about the party with the burden of proof, what we're referring to is the party that has to adduce evidence in order to establish that its case should succeed on the balance of probabilities. In other words, it needs to show that there is a 51% chance or better that it is right. And usually under English law, this burden will rest with the claimant, who will usually need to prove their case to the requisite standard of proof. And as I say, in a civil case, that's usually balance of probabilities 51% or better. And if it's 50-50, the claim will usually fail. Now, often this doesn't make much difference because the evidence will either be interpreted in favour of one party's case or the other. But the question of where the burden of proof rests can be important in a scenario where there are two possible causes of loss and responsibility for one rests with one party and responsibility for the other rests with the other party. Because in that scenario, the party with the burden of proof will need to show that it was the relevant cause that led or contributed to the loss, whereas it may be good enough for the other party's case to succeed if neither one cause nor the other is proven. And just to illustrate this point, these issues were considered in the Volcafe case, which went to the Supreme Court in 2018. And so that case arose from the carriage of a container of Colombian coffee beans from Colombia to Germany in April 2012. And when the cargo arrived in Germany, it exhibited signs of wet damage, and it was common ground between the parties that the moisture that was present must have come from the coffee beans themselves. So the cargo owners brought a claim against carriers under the bill of lading for a failure to comply with obligations under Article 3, Rule 2 of the Hague Rules, and a breach by the carrier of its duty as bailee of the cargo to deliver the cargo in the same good order and condition as it had been in upon shipment. And the fact that the claim was advanced under these two bases, under the Hague Rules on one hand and under a breach by the carrier of its duty of bailment on the other, was significant. So the claim in relation to the Hague Rules was effectively a contractual claim, and the carrier argued that normal principles in relation of burden of proof should apply. As we've just discussed, that would usually be, the burden would usually rest with the claimant. And bailment is a concept arising at common law, whereby a carrier has a duty to deliver the cargo in the same condition as the condition it was in when it was received for shipment, and provided the cargo interest can show that the cargo was loaded in sound condition and discharged damaged, then the burden will usually shift to the carrier to prove that the damage to the goods was not caused by its negligence. And this is sometimes referred to as reversing the burden of proof. And so in the Volcafe case, owner's primary defence was that the damage experienced by the cargo was in fact caused by an inherent vice of the cargo, In other words, it was caused by a deterioration of the goods that were shipped as a result of their natural behaviour. And where inherent vice can be established, this will be a defence to the carrier under Article 4, Rule 2M of the Hague or Hague-Visby rules. But as a secondary alternative case, the carrier also argued that where there were two potential causes of damage in play, i.e. in this case inherent vice and the way that the owners had cared for the cargo, the burden then was on the cargo interest as claimants to prove that the damage in question resulted from owners' failure to care for the cargo or their negligence only. In other words, that the conventional burden of proof position should apply that would ordinarily apply in any other kind of civil claim or claim for breach of contract. The cargo interests, on the other hand, argued that the bailment position should apply in relation to establishing the burden of proof. And it was irrelevant that the claim was also being advanced in the alternative under the Hague rules, and that therefore in this position where the cargo interest could show that the cargo was in good order at loading and damaged at discharge, the burden of proof should be reversed so that the carrier needed to disprove its own negligence in order to succeed with the defence of the claim. And in that scenario, where there were two possible causes of loss, again, either inherent vice or the way that the carrier had cared for the goods, it was the carrier to prove that it was inherent vice and not the alternative cause that actually caused the damage. And the Supreme Court agreed with the cargo interests and held that where the cargo is shipped in apparent good order and condition, but discharge damaged, the burden of proof does indeed reverse on the carrier to show that the damage was not caused by its negligence or its breach of Article 3, Rule 2 of the Hague Rules. And in other words, where there are two possible causes of damage, one of which is the carrier's responsibility and the other of which would amount to a defence for the carrier, it's for the carrier to prove on the balance of probabilities that it did not cause the damage. And on that basis, the cargo interest claim succeeded. Okay, so regardless of the position in relation to burdens of proof, but of course, where one party or the other has the burden of proof, these points will very much be brought into focus all the more. Both the cargo and the cargo interest and the carrier will want to make sure that, as much as possible, that they are equipped with all of the evidence they need to prove their case at each stage of the process. And as I say, of course, this will be even more important for the party with the burden of proof at each stage. So first of all, the cargo interest will need to be able to prove the condition of the cargo at loading. Okay, so a cargo interest will always want to make sure, wherever possible, that it has loading survey evidence where this is available, certificates of quantity and quality, particularly in relation, for example, to a bulk cargo. Analysis certificates might also be relevant, for example, in relation to a wet cargo. The representations on the bills of lading, as we've discussed in previous slides, might also be relevant, but they're by no means the full story. And there may be other contemporaneous evidence available to the cargo interests around the time of loading that they'll want to rely on. And then subsequently, the cargo interest will need to establish that the cargo was in a damaged condition at discharge. And they'll generally do this by means of further survey and analysis evidence of a similar kind that they will want to have relied on from the loading stage. Okay, and then for the carrier, on the other hand, it may not always be appropriate or economical for the carrier to carry out all of the pre-shipment testing on the cargo that cargo interests would ordinarily carry out. But the carrier, again, as we've seen on previous slides, will need to carry out a reasonable investigation as to the condition of the cargo on loading to make sure that it complies with its obligations under the Hague rules. And where there are any concerns in relation to the condition of the cargo at loading, appropriate representations will need to be made by means of clausing the bills of lading before the bills are issued. But perhaps most pertinent for the carrier, and particularly given the position on burdens of proof, as we've seen a couple of slides ago, is that the carrier will need to make sure it observes good cargo care practice during the voyage and to document all of the steps that are taken in relation to the care of the cargo during the voyage. So, for example, where there's a need to ventilate the cargo while the cargo is at sea, the carrier will need to make sure that it follows any instructions that have been given by the shipper of the cargo or the charterers. as well as following the industry best practice for the care and ventilation of that particular cargo, and to make sure that all of the steps that are taken have been documented. Because if there's no evidence of the steps that have been taken, in circumstances where the burden is on the carrier to prove that it did not cause the damage to the goods through its negligence, if there's no evidence to show that the carrier took the steps required of it, then that's likely to count against the carrier. The carrier will also want to test the cargo interest's evidence from discharge. So invariably, where there's a problem, particularly where there's a problem observed with the cargo at discharge, all interested parties will want to appoint their own surveyors to record discharge and to record the quality and quantity of the cargo that's taken off the ship. And invariably, there will be divergences between the evidence produced by the cargo interests and the evidence produced on behalf of the carrier. And often that will form the substance of a dispute, but more importantly for the carrier, it will form the basis, or may form the basis, for the defence of the claim and the exclusion and limitation of liability pursuant to defences available to the carrier under the Hague and Hague-Frisbee rules. And the final thing that the carrier will want to consider in its defence of any claim is whether the cargo interest could be said to have failed to meet its obligation to mitigate its loss. And mitigation refers to the obligation on the victim, using that expression, of a breach of contract, not to increase its loss by acting unreasonably. And if it is established that a loss has been increased through the unreasonable conduct of an innocent party, then the innocent party's claim will be reduced by the corresponding amount. However, it also has to be kept in mind that the innocent party does not have to take the most cost-effective option available to it, and is given quite a lot of latitude in terms of the steps it could take without falling foul of a mitigation argument. In other words, there is a high bar for a defendant to meet before it will succeed with any argument that the claimant has behaved so unreasonably that its damages should be reduced for a failure to mitigate. And this issue, among others, was considered in the case of AMS Ameropa and Ocean Unity from last year. And that case was interesting interesting in a sense, because it was actually a fairly run-of-the-mill cargo claim relating to damage to a cargo of 50,000 metric tons of soybeans shipped from South America to China. And the cargo was loaded in apparent good order and condition, and there was no question in this case that the bill should have been claused. But on discharge, damage was discovered to around 3,600 metric tons of the cargo. Cargo interests then argued, I should also say that it was common ground that the damage to the cargo was caused by something on board the vessel, probably some kind of heating that was going on underneath the cargo hold, causing damage within the stow in the area of the hold immediately adjacent to where the heating was taking place. And so the cargo interest advanced a claim in respect of 3,600 metric tons of cargo, and that was the quantity of damaged cargo, so the cargo interest said, that was removed from the ship and placed in a warehouse at the discharge port. Claim was advanced in relation to that amount of quantity of cargo, together with expenses incurred by the cargo interests, less the salvage proceeds that were achieved for the damaged cargo, giving rise to a claim of around $417,000. And the owners argued that the damages should be, first of all, they argued the damages should be based on an actual quantity of damaged cargo, which they said was much lower, in the region of 15 to 88 metric tons, and they had used expert evidence in support of that contention. And they also argued that the owners had failed to mitigate their loss. And they said they'd failed to mitigate, first of all, because they should have done a better job of segregating the damaged cargo from sound cargo, and that 3,600 metric tons could have been reduced considerably, so owners said. And secondly, they said that the cargo interest could have achieved a better salvage deal for the damaged cargo. For example, by looking further into the market and seeking some further salvage bids, and basically spending more time and money effectively on trying to obtain a better deal for the salvage cargo. Okay, and so when giving her judgment, the judge actually preferred the owner's evidence in relation to the facts of the case, and indeed the expert evidence that was put forward on behalf of owners, particularly in relation to the fact that the actual damaged cargo within the stow was probably limited to around 70 to 80 metric tons. However, despite this, the judge also found that the cargo interest's approach to mitigation had been reasonable and rejected the owner's claims that the cargo interest approach to segregation and obtaining salvage bids were unreasonable. She accepted that the cargo interests, for example, were not obliged to incur substantial further costs in relation to trying to segregate sound cargo from damaged. It would also potentially have commercial implications if that went wrong and the cargo interests were found to be releasing damaged cargo into the market, via their commercial contacts. She also held that the cargo interest approach to obtaining a salvage value for the cargo were reasonable. Again, she found that the original sales invoices for the cargo were good evidence of the sound-derived market value at destination. She also found that the fact of the salvage sale itself was good enough evidence of the value of the damaged cargo, and deducting one from the other gave you the salvage value of the cargo, and she was prepared to accept that evidence. She did not agree with the owners that the cargo interests were obliged to look further into the market to try to obtain the best possible value for the damaged cargo by means of salvage sale. And this it illustrates the wide scope that innocent parties in the position of cargo interests are given in relation to steps taken in mitigation.
Thank you, Tom. So just to conclude and summarise, bills of lading are prima facie evidence of the statements stated on the bill. So, for instance, the weight and quantity of the goods shipped, the apparent order and condition of the goods shipped. But these can be displaced by extrinsic evidence to the contrary. So, for instance, if you have a load port survey which contradicts a statement on the bill, then because the bill of lading is only prima facie evidence, it can be displaced. But do bear in mind that the statements on the bill of lading can be conclusive evidence against a third-party endorsee acting in good faith. So that's the situation where a consignee, a third party has bought the goods in reliance on the fact that a clean bill of lading has been issued, and they are entitled to rely on that statement as against the carrier who's issued that bill. We talked about how a master may clause a bill of lading, and there may be unknown provision limiting the evidential effect of a bill of lading. Tom then went through the burdens of proof, the law and burdens of proof, and in particular the Supreme Court's decision in Volcafe, which to summarise is that if the cargo interest can discharge the burden of proving that the cargo was loaded in sound condition and discharged in damaged condition, the burden then shifts to the carrier to prove that the damage to the cargo was not caused by its breach of duty. Generally, I would say it's in both parties' interests, in the interest of both the cargo and the carrier, to obtain detailed load port and disport evidence. This isn't going to be proportionate to do for every containerized cargo, but if you have a particularly valuable cargo, and in particular a large bulk cargo, it's a good idea to have your own surveyor at the load port and the disport. And then lastly, because of the decision in Volcafe and that burden on owners to prove that that any damage was not caused by their breach of duty, if you're acting for owners, evidence of onboard practices such as ventilation or maintenance can be absolutely vital to defending a cargo claim. So detailed records are important.
Okay, so now we move on to the part of the webinar where you have the opportunity to ask some questions. And I'm just waiting to see what might come through here. I think I've seen one question in relation to containers, which has come through to me privately. So the question that I've been asked is that we mentioned earlier on in the talk that a master, when considering what representations to make on a bill of lading, is required to do in relation to containers, and we just touched on this very briefly earlier on in the talk. And the question is that, so you mentioned that a carrier is not expected to look inside containers to check the condition of the cargo, but what observations is a master expected to record about the condition of containers loaded on board a ship? Well, the short answer to this is that generally the master or the ship owner's obligation, or I should say more accurately, the carrier's obligation in this regard is to make observations in relation to the external condition of a container. So really, it's if the container has suffered any significant damage, possibly that the seals have been broken, damage to the doors, obvious dents on the container. It would certainly be prudent for the carrier to make a record, of that kind of condition. But it's actually a topical question because there's been a very recent authority, specifically in relation to the question of where there's a discrepancy between the weight of a container loaded and the weight recorded in the shipping documents. And what happens in that case? So the case was advanced by a Greek metal trader who shipped a container on board of a Maersk vessel. And the unfortunate metal trader was subject to a fraud. And what had happened is that the copper that was supposed to be inside this particular container had been replaced by breeze blocks. And so as a result of that, when the container was loaded on board the ship, there was a significant discrepancy between the actual weight of the container and the weight in the shipping documents, including the draft bill of lading, as to what the container in question should actually have weighed. And upon loading, the carrier, who was actually Maersk in this particular case, did weigh the container, but they weighed the container for stowage purposes, safety purposes, to make sure that the vessel remained balanced, during the ocean voyage. And they didn't tie up the fact that the weight taken for that purpose didn't tally with the shipping documents. And so the cargo interest brought a claim against Maersk that Maersk was stopped from relying on pre-shipment damage, i.e. the fact that essentially the wrong cargo had been loaded in the container, because it should have claused the bill having in its possession the information regarding the actual weight of the container and obviously the discrepancy on the draft bill and the shipping documents. But the High Court, it was Lionel Percy KC, sitting as a Deputy High Court judge, found against the cargo interest in that scenario, and said that there is no obligation on a carrier in relation to containers to actually check the weight of the containers and check that they tally with the shipping documents. That goes too far. On the other hand, there is a slight word of caution there that if in fact the master or the department within Maersk who had the responsibility for issuing bills actually had in its possession the information relating to the weight of the container and was in a position to compare the two, then there could be a scenario where the carrier could lose the right to raise a pre-shipment defence. But in general terms, it's not on a carrier, not a carrier's responsibility to check that the weight of containers tallies with the information in bills of lading and other shipment documents. So that's a rather long answer to a fairly simple question. The question being that in relation to containers, the obligation on a carrier is generally to record the any issues with the apparent condition of the outside of the container. Any other questions? No such thing as a silly question, so do feel free to raise anything. And if you don't want to raise it now, on the live webinar, do feel free to contact us afterwards. We're very happy to pick up any questions or indeed to speak. So, there's one new post here. Let's have a look.
We've got one on liquid cargoes here. For liquid cargoes, where the carrier will also participate in a ulaging post loading, and the bill of lading quantity figure is consistent with such ulaging, would the weight quantity unknown clause still affect the evidentiary value of the bill of lading? I think the answer to that, although don't know how to consider it in practice, is that the eulogy report would in effect be extrinsic evidence of the quantity loaded. So it wouldn't affect the bill of lading, but it would be evidence in itself.
Yeah, I agree with you, Alex. I think so. So generally, as Alex was explaining earlier in the webinar, the position is that the bill of lading will provide prima facie evidence of the condition of the cargo. Where you then have extrinsic evidence, such as ullage reports or analysis results, other tests that have been carried out that militate against the representation in the bill of lading, then the evidential value essentially of the statement within the bill of lading can be displaced by that extrinsic evidence. So I think in that circumstance where you've got an ullage report that shows something that's contrary to the position that's set out in the bill, you would certainly argue in cargo interest position that the extrinsic evidence, the ullage report, should take precedence over the statement. Okay, I'm just reading the other couple of questions that we've had. So let's have a look at this one. So given the increasing reliance on electronic bills of lading in international trade, what are the key evidentiary challenges and potential legal implications arising from their use in cargo claims? Well, that's a pretty kind of broad question, which slightly goes outside the scope of today's talk. But you're absolutely right to raise, the wider question that arises in relation to a kind of a changing custom, because the world of shipping has been used to dealing with physical bills of lading for 500 plus years since they first came into use. And the kind of the means by which title under a bill, for example, passes through the means of not only an endorsement, but also the passing of actual physical possession of the bill. And that's well enshrined in, for example, English law. And there have been kind of various ways that people have tried to get around that, or kind of innovate in order to address some of those challenges. For example, the use of things like blockchain, closed systems where instead of actually passing physical possession, there's a recognized means of actually passing electronically the equivalent of passing kind of possession of a bill of lading, for example. I mean, none of that, certainly in our position as shipping lawyers, we don't see that usage or the issues and disputes that arise out of that. They come across our desks fairly infrequently so far, but no doubt that will be something that that increases in volume in terms of work as time goes on. Alex, I don't know if you've got anything to add to that.
No, we've got another question here. In the case of an order bill of lading and possessing a full set of original bills of lading, is endorsement to the notified party a prerequisite for cargo discharge? I think so the notified party, the first point is the notified party is a bit of a misnomer. I mean, it can be endorsed to anyone. It doesn't have to be the notified party. So don't put too much emphasis on on what it says in the notified party box. But if it's just to order, and then if it's just to order and hasn't been endorsed in blank or otherwise, it would be to the order of the shipper. So you would need to take instructions from the shipper regarding who to discharge the cargo to.
Yeah, exactly. And the questions of the passing of title under bills of lading were actually addressed in an earlier talk. So that's not really what we're kind of focusing on today. But if you have a look at webinar number 2, then these issues were addressed in detail. So dig that one out. There should be a link to it on your invitation to this webinar. So it's probably worth watching that one. And if you've got any more questions, then do get in touch with us. Okay, so I think we've got time for one last question. What kind of damages did cargo interest recover in the case of the damaged bag from the fire at the warehouse prior to loading due to the carrier's misrep on the bill of lading for the quality of the goods? As the damage occurred outside the carrier's liability, as per Hague-Visby, could the claimant recover? Well, no. So the analysis here is that because the carrier, so the question here, just to summarize, is that in relation to the case where there was pre-shipment fire damage caused to the bags that were subsequently loaded on board the ship, what kind of damages were recovered, and did this fall outside the carrier's sphere of responsibility under the Hague-Visby rules? And just to take that second point first of all, usually as the question kind of indicates, you'd be absolutely right that the pre-shipment damage would not normally be a carrier's responsibility. The problem that the carrier had in that case was that because it failed to clause the bill, it effectively accepted responsibility for the condition of the goods at loading, regardless of what condition they were actually in. And as a result of that, the view of the courts effectively is that the damage did occur during the period of the carrier's custody of the cargo. Okay, so on that basis, the Hague-Visby rules did apply. And in that particular case as well, the weight and package limitations in Hague-Visby didn't assist the carrier, because the individual, the weight of the bags was the weight and number of the bags was above the relevant limitations. So I think the claim was advanced for about $2 million, and the cargo interest recovered most of that amount. The issue is that even if there's pre-shipment damage, if the bills aren't claused, then it's viewed by the courts that the damage effectively occurred while the goods were in the carrier's custody. That's what happened in that case. Good. Well, it's 11:01. Good timing. Thank you all very much indeed for listening. I hope that was helpful. And do watch out for our next webinar, which is coming up in hopefully this side of Christmas, which will be on general issues arising in relation to cargo claims, with Henry Adams, Pamela Dunning, and Sarah Holsgrove. Thanks all, and enjoy the rest of your day.
Thank you.